Someone make it make sense.
Probably a couple.
Hello, and welcome everybody. Welcome on in. Have a cough drop. Just kidding. Oh boy. Okay, so we're having some weather here. Hopefully it won't interfere with anything, but we're having some heavy thunderstorms and whatnot. So hopefully we will be all good. It looks like it's supposed to subside around in like a little bit of like a little over an hour. And then pick back up. Anyway, I'll keep an eye on it. Hopefully it'll be fine though. I mean, if something happens and all of a sudden I disappear, just know I either lost power or internet or both, essentially. Welcome, Black Witter. Welcome, Candace. Happy to see you guys. Also, and welcome as well, Angel. Angel throwing some cough drops in the chat. Freaking love it. I should make an emoji with these actual cough drops with the wrapper. That'd be pretty funny. Angel changed her picture again to looks like an angelic type of thing there. So yeah, happy to see you guys. So also bringing the cough drops. Black Witter also loves cough drops. See, it's not just me. Excellent. I know Meg is like worried that I'm going to become addicted to cough drops. And I'm like, is that even a thing? She says it's a thing apparently, but I'm like, you don't have to worry about that. They're just great. They're just delicious and awesome. And I have a whole pile. So yeah, welcome on in, help yourself to a cough drop. Shout out to Maisha. Welcome as well to Maisha here. So guys, this also will redirect you guys through the magic of Lori's portal into our next live stream. And for that one, I'm just remembering all the different features we have for members. And so one of the members features that we have is members only live chats. So that will redirect you guys into the live stream. The live stream will be viewable for everybody, but the live chat will be members only. So shout out to all of our channel members. And that video we are going to be watching. Law and Crime has a new video that was called like Shocking New Details in Idaho Force. This is Idaho v. Coburger, right? And I haven't watched it yet. I don't know what they're going to say. I thought it would be a fun thing to do to find out together what they're going to say are the shocking new details. I don't know what to expect, but we will find out and learn together. So I'll put the link in the chat as well for anyone who is interested and wants to become a member. Black Witter, following up with the cough drops. I really love them, like really, really. Yeah, me too. I know Official, shout out to Official, has also been eating some cough drops recently too. So yeah, let's see. Did I go ahead and greet everybody here in the chat? Let me just make sure that I went ahead and put all those commands in for everybody. I think I did. How's your training going, Candace? Candace is training for a marathon. So raise your scroll paw if you're surprised that Lori Vallow has filed a motion for a new trial. I'm not raising my scroll paw. So here we go. All righty. Motion for a new trial. To the Honorable Judge Boreski. Lori Daybell requests that the court grant her a new trial. Wow, I've literally never seen a motion for a new trial start with like this. It's just so, what's the word I'm looking for? Like, is pedantic the word I'm looking for? Hold on. Pedantic? I don't know if that's the word I'm looking for. No, not pedantic. The opposite. It's like informal. It's like, what is the word I'm looking? Anyway, it's just not. It doesn't sound scholarly. Need another word. Oh, Candace, that's awesome. Walking home loaded down with weeks of shopping. See it as weight training. Well, be safe as you try to carry all your stuff and also be in the chat. Be safe. Safety first, guys. Okay, anyway, this motion is filed pursuant to the protections provided by Rule 24.1. Basic, also welcome. We have a new squirrel friend, guys. Fair Green 42. Welcome, welcome, welcome. Yeah, peasanty. is another way. This is kind of thinking along those lines. Like, what's another word for that? Like peasant-like. But welcome on in, Fair Green. Happy to meet you. So the Arizona Rules of Criminal Procedure. Okay, she's just citing, and of course, as per usual for her, she cites the Constitution. Classic glory. Classic glory. This motion is accompanied by the following memorandum of points and authorities. Okay, facts. She starts out with juror misconduct. Oh, this is going to be good. On April 28th, 2025, it came to the attention of this defendant's advisory council and later the court that juror 15 made a statement indicating he had knowledge of this defendant's prior conviction. It should say the defendant's, not this defendant's. Anyway, Exhibit 1, clip Fox 10 News. He also indicated that he was leaning towards a not guilty vote up until yesterday. Up until yesterday? Oh, this is a mess. Okay. If that's what he said, you need to quote him. Up until yesterday, if those were the words that he used, you need to be quoting him. But if you're not, then you need to say, when is yesterday? We have no idea. This was just filed. Oh, what a mess. May 1st, 2 days ago. So yesterday was the end of April. I mean, wow. Up until yesterday and through deliberations. Yeah, it sounds like that's a quote, but she says it's third person. Okay. He also indicated that the quotes would probably start here. I mean, I don't know. He was leaning. No. It would be he also indicated that he, and then the quotes would start here, was leaning towards a not guilty vote up until yesterday through deliberations, end quote. Assuming that's what he said. But this is a mess, so I have no idea. This prior conviction involved the homicide of her children. Oh, so now her children in Idaho in 2023. This defendant, the defendant, did not testify in the trial. And the conviction, I'm editing this for her. The conviction was not presented by the state as Rule 404B, other act evidence. Oh my God. Thus, juror 15 should not have learned about this information. Because this case was a high-profile matter, once the jury was released from its admonition, there should be another comma there, jurors were free to speak with media. During an interview, juror 15 was asked about his reaction upon learning about this defendant's prior convictions. He stated the following. At least she's using quotes here. You know, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell. Yeah, I'm surprised you feel sorry for her. Nicer fellow than I am. Not that I'm a fellow, but you know what I mean. And that's it. That's literally all she's saying. You've got to be kidding me. What? Okay, so here's the thing. So she's trying to say that this juror gave an interview that implied that he knew ahead of time. Okay, so remember when the jurors spoke out after the verdict? They were literally flooded with a bunch of media, and the media was telling them about her other convictions and stuff. And that's how they were learning. That's what was said, right? So she's not I don't understand. What is she trying to say here? Is she trying to say that somebody knew before? She's not made this clear at all. This is a mess. I don't understand what she's saying, because if they found out immediately after they were done, then this is, I just don't understand. If she's trying to say that this person made a statement and this was before the verdict or something, or just at any point during trial, right? Before they were released, that was not made clear in any way, shape, or form. And then that could be problematic. That could be problematic, but she's not made that clear. So good luck, Lori. Jesus. And she's starting with this. Now, I would imagine that her advisory council probably told her that the way you want to do this, right, when you're making a motion for a new trial, is you want to start with your strongest points first. You always lead with your strongest points. So this is supposed to be, y'all, her strongest point that she's going to argue, right? And that's what we got. Wow. Just wow. And Maisha, that's so funny. I did actually shout you out when we got to that point, and I did reference that. I don't know if you watched it on replay, and I haven't done timestamps yet because I'm just behind, but I did reference Maisha. I was like, oh, I know Maisha would want to be here to give us her list. So thank you. Okay, well, there we go. So now she's got her second strongest ground for a new trial. All right. Preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Coombs. Prior to trial, the court precluded this defendant from presenting to the jury any of Tylee Ryan or Alex Cox's statements. Both of these people were present during the shooting of Charles Vallow, and the sum of their statements were not hearsay, as they show effect on listener pursuant to Arizona Rules of Evidence 8033. All right, let's take a look. Because she's not actually citing the rule, no surprise there, like as in providing the rule. And my guess is it's probably exactly the same as it is in the federal rules, which is usually the case. So let's take a look. I mean, we know that this is not accurate in some form or fashion, or they wouldn't have been precluded. Okay, 803.3. 803.3. Oh my God. Holy crap. Okay, here we go. All right. All right. Let me explain why she's confused. Okay, so 803, we know those are the exceptions to hearsay, right? 803.3 is then existing mental, emotional, or physical condition. Now, Elaine got really confused with this and Debbie heard whatever. That's a whole conversation for another day. Wow, what is wrong with her? Okay, I'm going to read this verbatim. A statement of the declarant's then existing state of mind, such as motive, intent, or plan, or emotional, sensory, or physical condition, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the validity or terms of the declarant's will. I think they mean will there as in like will and testament, like, you know, your last will and testament. But here's the thing that matters here, right? It's reflecting the then existing mental, emotional, or physical condition of the declarant. Point one. So where's the first problem here? She says effect on the listener. Are you kidding me? This is worse. This is already worse than I would have imagined. What? Okay. No, does not say that. And also literally, I mean, yeah, okay. But also the next point here, right? But not including a statement of memory or belief to prove the fact remembered. Here's the thing. Lori wanted these statements in to prove the truth of the matter asserted, right? So literally, you pull it back up again here, or open, not pull it back up. It's in my book. Literally here, it can't be a statement to prove the fact remembered. And you guys know exactly why she wanted to include these, to try to prove the facts of what they said, which was the story about the self-defense thing. She wanted to offer them for the truth of the matter asserted, right? That's why she wanted them in, which is why it's hearsay, which is why you need a valid exception. Oh my God. Yeah, she does want it that way. She wants it that way. Yep. Oh, that's fun watching the Kentucky Derby. I love horses. I believe she wants it the same way that Elaine. Yeah. I mean, no. But also, this is the funniest part potentially here. The effect on the listener is not in anything. So there you go. The state filed a motion eliminate throwing a blanket hearsay objection over the entire statements. Yeah, it's being offered for the truth of the matter asserted. The court indicated in a pretrial ruling that it would, at least to Alex Cox's statement, take it on a statement-by-statement basis. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler police detectives during that walkthrough. No, the walkthrough came up. And I don't know, the only reason she would even care about the walkthrough is for this reason. She wanted to get his statements in. The walkthrough came up. I remember that. I remember the walkthrough. Then in the state's, and she's missing a comma here, in the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. This defendant objected to his testimony as an expert witness based on the lack of foundation and her not having had time to rebut his professional opinion. The foundation was laid. I'll just go ahead and say that much. Again, this defendant was precluded from discussing Alex Cox's, the shooter, walkthrough that was conducted with several Chandler police detectives, including Detective Coons. This walkthrough was precluded as inadmissible hearsay. However, right, because statements, the walkthrough, the fact that there was a walkthrough came in. We heard that, dude. What is wrong with her? Well, we know there's a lot wrong with her, but what I mean is this, that she's trying to say, oh, the walkthrough couldn't come in. No. The fact that there was a walkthrough and the statements made during the walkthrough are two completely different things. And why does she want the statements in? Say it with me now. To prove the truth of the matter. What he said as if that's fact, right? Hearsay. It's inadmissible hearsay. Oh my God. However, it formed the basis for Detective Coons' questioning with the medical examiner and how he then investigated this case, as Alex Cox indicated he shot the victim in self-defense. What a mess. Discovery violation. Okay. On April 14th, 2025, during trial, Ms. Trina, this has already been litigated. Oh my God. Ms. Trina K produced a hard drive containing the gray key information for Charles Vallow's cell phone. She's missing the apostrophe S. Contents of the hard drive are exculpatory evidence. Oh my God. You can't just say that. You literally, look at this, you guys. She says they're exculpatory. She doesn't even cite Brady. She doesn't give any standard for exculpatory. She just says they're exculpatory. This is insane. I mean, I would have expected her to at least cite Brady, Giglio, even if she doesn't explain how it is exculpatory under those standards. I would at least expect her to cite that. This is, oh my God. Oh my God. Oh my God. Defense had been requesting this evidence so that she could provide it to her independent expert for his review. The discovery disclosure occurred in the middle of trial. No, it was before trial because I remember them litigating. We watched all these hearings, dude. Yeah, so excellent question here. Sophia Green says, I understood the state of mind exception works like if somebody describes things in the moment they happen. Like if Kyle, I think you mean Kaylee called 911 and said, right. Or Tylee, you mean, sorry. Like if Tylee called 911 and said he's coming at us with a baseball bat. So, that would be an excited utterance. But here's the thing, is that if so that's that. Okay, that is true. Like if something's happening and somebody calls 911 and then they make that statement in the moment, this thing's, oh my God, whatever thing is happening. Absolutely. That 100%, that's an excited utterance. That's an exception to hearsay. The problem is that nobody did that in this case, right? But also Lori is saying, she's trying to say the effect on the listener. Big difference. Effect on the listener, as in how it affected her or a listener, right? That is, I've never even seen anyone try to argue that. Because it's all about the declarant, right? That every exception to hearsay has to do with the declarant. The declarant's then existing state of mind. The declarant, for example, if you're thinking present sense impression, it's the declarant's present sense of impression. Or if it's an excited utterance, it's the declarant's excited. The declarant is the person making the statements, which that would be Tylee, that would be Alex. She's saying to show the effect on the listener. What? That is in no exception anywhere in the rules. Hopefully that makes sense the way I explained it. Yeah, I mean, it just basically, she just doesn't understand how things work. I mean, hearsay is complicated, but like, this is pretty simple. If you look at the rule, that's not in it. Not to mention, they don't show an effect on the listener, right? They literally don't. It's like, in other words, the reason she wants them in is to be like, to validate it, like, oh, law enforcement believed them. That's why you would say showing the effect on the listener, as in the effect on the listener being that law enforcement listening believed them, right? But that is not at all in any way, shape, or form allowed. Like, yeah. The other thing is this, right? Her biggest hurdle with that is that it's self-serving hearsay, as in self-serving for her. And the declarants are unavailable because she killed them, at least with Tylee, at least as it pertains to Tylee. Now, she didn't make a distinction and argue it separately, Tylee versus Alex, right? Because, Alex was ruled natural, although everyone has thoughts on that. But at least as it pertains to Tylee, declarant unavailable because she killed them, right? You can't then, because normally you would call the defendant or not the defendant. Normally you would call the witness to the stand and have them testify to what they thought happened or whatever. But in this case, the declarant, right, is unavailable, as in Tylee, because Lori killed her. And so that adds a whole other layer. That was one of the main reasons why that couldn't come in too. Okay, so now we move on to the discovery violation. All right, we already read this one, right? It was just so incredibly short and amazing. All right, prosecutorial misconduct. On April 8th, 2025, the state elicited irrelevant, prejudicial, and improper character evidence when it asked, because you're referencing the state. Chandler fired Captain Keller if he had overheard any conversations with this defendant. Ms. Trina K asked Captain Keller on direct examination, and there's no quotes. Oh, God. Did you overhear this defendant talking with the police? He responded in the affirmative, stating he overheard someone stating, oh, my God, not getting invited to pool party because of the commotion at the house or something. This statement caught this defendant off guard, as Captain Keller indicated during his interviews with Chandler police just after this incident occurred that he only saw the male outside on the curb and did not ever mention seeing this defendant. It caught her off guard. Oh, so that's prosecutorial misconduct, according to Lori. During closing arguments, while addressing the justification defenses, Ms. Trina K told the jury, wow, there's punctuation missing, that this defendant was not entitled to any of these self-defense instructions. They were still read the self-defense instructions. Oh, my God. What she was saying is, here's why they don't apply. And this is totally normal and is done in every case. And when, as one should, they go through the jury instructions during closing arguments. Wow. Ms. Trina K also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. I will just say that these are not real issues, but should she have had issues at the time, she should have objected, and she did. Ms. Trina K knew from previous testimony, interviews, and pretrial defense interviews that Summer had begged Alex to go, oh God, this is insane, over to this defendant's home because of Summer's concerns for the defendant's safety. Finally, Ms. Trina K commented several times on defendant's demeanor during this incident, drive to police station, and on the body camera, and told the jury you did not see her cry in that interview. Yet, knowing there were portions of this defendant's interview that had been cut from the full interview, irrelevant. They watched the whole thing, dude. Admitted by the state where she sat in the room, did not show emotion, and could be seen grabbing a Kleenex. Seen grabbing a Kleenex is different. And dude, oh my God. I cannot wait to see the responses to this. I can't wait. I would rip it to shreds. This is a mess in so many ways. She moves on to calling the judge biased, as if it couldn't get worse. Court's lack of impartiality. The court precluded this defendant from presenting a defense by striking her witnesses, including but not limited to Nate Eaton and Brandon Boudreaux, wow, before they were even called to the stand. Well, that's when you would strike them, obviously. Specifically, before testimony began, the court required this defendant to establish on the record what relevancy her witnesses would present. Yeah, and you couldn't. You couldn't establish any relevancy. Evidence, and remember, witness testimonies is evidence, right? For evidence to be admissible, it has to first be relevant. You guys that are watch this channel, y'all know that is the first test. Is it relevant? And she could not provide it. We watched all those hearings. This required this defendant to state in front of the prosecutor her defense strategy. Nope. This is not required under the law or any rule of evidence. Lori, during cross-examination of a civilian witness, Serena Sharp, in relation to testimony regarding religious beliefs, spelled wrong, the court commented during the prosecutor's objection to relevancy, stating, I guess to the extent you're comparing yourself to these biblical figures, I will allow it. That was him being fair to you, Lori. He could have totally sustained that objection, and he didn't. I remember this very well. Wow. Part of the state's case was to establish that this defendant had stepped outside the Mormon religion by claiming she was a translated being. Specifically in text messages saying she would be like Nephi, and that these messages were nothing more than part of the conspiracy to kill Charles Vallow. This defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of questioning. Yeah, he allowed it. He allowed it. What? He allowed it in. Wow. I'm just blown away right now. Right. Well, and the thing is she didn't actually have any tears. Even Lori herself says she just grabbed a Kleenex. That's, we see this all the time with people, right? When they're not actually crying. However, we all know that the jurors that spoke out said that the first thing they did was they watched the entire thing. And literally they were like, we don't know why she wanted us to watch it because it made it worse for her. Which, we all expected, but, Argument and authority. The Arizona Rules of Criminal Procedure provide that a court may grant a new trial when a juror or jurors have committed misconduct by receiving evidence not properly admitted during trial. Additionally, a new trial is appropriate if, for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. The defendant is entitled to a new trial because the jury received and consulted extraneous evidence. And now she's at least citing a case here. I would agree, but she didn't show that this happened. Like this says, once the defendant shows the jury received and consulted extraneous information, prejudice must be presumed and a new trial must be granted unless the state proves beyond a reasonable doubt the information did not taint the verdict. She didn't show that this happened. Oh my God. At least she's citing case law. When a juror does not base his verdict or on evidence developed at trial, he violates the fundamental integrity that of all that is embraced in the constitutional concept of trial by jury. Such misconduct by jury members denies criminal defendants their rights under the 6th and 14th Amendment to confront and cross-examine his accusers about that intrinsic evidence. That's the 6th Amendment. Why is she saying 14th Amendment? Okay. This defendant's advisory council and the court both received evidence that the jury's verdict was tainted when Juror 15 spoke during his interview with Fox 10 News, disclosing that he had learned of her prior conviction seemingly one day prior to the admonition being lifted. Because it is clear Juror 15 had information it's not clear. You did not make it clear, and that you have that burden. Once you've been convicted, remember the burden shifts, right? The burden shifts. If you want to show juror misconduct or prosecutorial misconduct or any of this anything else here, the burden is now upon you, Lori. Because it is clear, not clear, that Juror 15 had information he was not entitled to know prior to conducting deliberations, the burden is on the state, to prove beyond a reasonable doubt that his information did not taint the verdict. This is very much Murdoch-y. Now, I will say, now this varies by the state, right? Okay, let me be clear. She says it's clear that he had information he was not entitled to know. That was not, she has the burden to show that first. She didn't do that. If indeed she did show that, then she's right that now the burden is on the state to prove that it didn't taint the verdict, just like in Murdoch, right? The two prongs. But the first burden hasn't been met, which is her showing that the juror had information he wasn't entitled to have. She didn't show that. So therefore, the second burden doesn't apply. That only applies when the first burden's been met, right? Dude. The state will not be able to meet this burden, and this defendant is entitled to a new trial. Even if an offending juror may have not influenced the other jurors, unanimity is required to convict a criminal defendant, and the jury's conclusion may have been different had the juror not consulted extraneous sources. We still don't know that happened. So, in Cornell, a juror looked up definitions that were neither admitted into evidence nor included in the trial court's instructions. None of this is relevant because none of this happened. I just can't. This is all completely irrelevant. More irrelevant than other things in here because of the fact that she didn't show that anything happened here. No. Okay, now we're on to the statements of Tylee and Alex. A new trial is appropriate if, for any other reason, not due to the defendant's own fault, the defendant has not received a fair and impartial trial. By precluding Tylee Ryan and Alex Cox's statements, this defendant was prevented from presenting part of her defense at trial, and thus she did not receive a fair and impartial trial. The court made a pretrial ruling that, at least to Alex Cox's statements, it would make a statement-by-statement ruling. Instead, this defendant was even precluded from discussing Alex Cox's statements during his walkthrough. These walkthrough statements formed the basis for Detective Coons being able to testify as an expert. No, I'm sure that's not correct. Literally, that is not the basis for testifying as an expert. And she knows that. I mean, she has to know that. I think she's playing dumb here. Yet she was precluded from cross-examining him on this foundation. Foundation is completely different, Lori, than trying to get in hearsay. For this basis, the defendant is entitled to a new trial. No, I disagree. And then we have this discovery violation that was already litigated. Oh, God. I'm not going to read all this. They already handled this. This was done before trial. Now we have acts of prosecutorial misconduct entitles this defendant to a new trial. She's citing the same rule here, or case law. Captain Keller. Second, it is improper, dude. Oh, wow. What a mess. It is improper for a prosecutor to misstate the law or evidence during closing arguments. Ms. Trina Kay stated this defendant was not entitled to self-defense instructions, yet they were clearly provided to the jury. Ms. Trina Kay also gave false statements in her closing argument by stating Alex had no reason to be at this defendant's home and that the defendant told him to bring a gun and extra ammo. That's not false statements. That's facts for the jury to decide, and she's allowed to argue it the way that the state views it. Ms. Trina Kay knew from previous testimony interviews and pretrial defense interviews that Summer had begged Alex to go over. You know what? If it didn't come in at trial, it doesn't count, Lori. And let's just start there. Never mind the credibility of anything that Summer said, according to Lori, first of all. But never mind that. She can't say, dude. She's making the closing arguments based on the evidence that came in at trial. That's what you're supposed to do. So this is insane. Saying that she should have known better because of these pretrial defense interviews. Lori, you could have called Summer to testify, and you didn't. That Summer had begged Alex to go over to this defendant's house because of Summer's concerns for defendant's safety. Lastly, commenting on this defendant's demeanor, specifically stating this defendant did not cry during her police interview, was improper comment, as she had cut this portion out of the exhibit and called it a full interview. They watched the whole thing. Dude, I can't. All of these comments add up to prosecutorial misconduct. And she left. She forgot a period at the end. That's great. That's great. That's great. Welcome, Miss Mojo. Wow. I mean, right there, you forgot the period at the end of the sentence. Wow. Now we have the the judicial bias. The judge commenting on the evidence during this defense cross-examination. This is insane. A defendant may move for a new trial based on the court's lack of impartiality. While under the law, a trial court is presumed to be impartial and free from bias. Oh, that's an incomplete sentence. This defendant can rebut this by the preponderance of the evidence by showing the court required her to present her defense strategy to the state for calling any witnesses. That's not what happened here. Rule 15.2b of the Arizona Rule of Criminal Procedure requires a defendant to disclose for each listed witness other than the defendant that the defendant intends to call as a witness at a trial in support of the defense. The rule requires the defendant to list the name and address of each person, which we know she couldn't do that for like a lot of her witnesses. I think maybe all of them. Other than the defendant intends to call as a witness at trial, and any written or recorded statements of the witness. There is nothing in the rule that requires this defendant to present her defense strategy in order to call witnesses. Nope. No one's saying that happened. The Fifth Amendment of the United States Constitution provides this defendant the right to subpoena power. She's just skipping over the relevancy test, which is ridiculous. This preclusion of witnesses and requirement of this defendant to inform the state of her defense prior to calling any properly noticed witness shows a specific claim of partiality. Second, for the record, establish that the court commented while responding to the state's relevant objection, and that comment showed a specific claim of partiality by casting doubt onto this defendant's credibility on the religious issue and in general showing she cannot be trusted. The court commented to a relevancy objection. I guess to the extent you're comparing yourself to these biblical figures, I will allow it. He let it in. He let the statement in. Can be seen as injecting his own opinion as to this defendant's reliability during cross-examination. I mean, I think that there maybe could be a way you could try to argue that as being problematic. I don't think it would be successful. But regardless, she's not making an argument that makes any sense here. Not to mention, he let it in. He didn't sustain the objection. This comment is even more important when it is taken into consideration that juror 15, now she's involving the juror again. In the Fox News clip indicated he ultimately made a decision to vote guilty based on 2 text messages, including the one describing I will be like Nephi. The court inserted his own improper comment when a simple overruled or sustained was warranted. This in and of itself shows a lack of impartiality and requires a new trial. I mean, the best point she's made is that a simple overruled or sustained can be, I mean, I suppose is probably the best way to do it, right? Or before you say overruled or sustained, you can say response. You can ask for a response. But it is not uncommon for judges to give their reason for sustaining or overruling an objection, right? That is far less problematic than somebody like Judge Bev, who's like no grounds, right? Period, for objections. And honestly, it was very fair of him, in my view, and generous of him to let that in anyway. So, conclusion, given the above reasons, this defendant respectfully requests the court grant her motion for a new trial. I cannot wait to see the responses from this. We should be hearing from the prosecution. Then Lori is going to be allowed to make a response to that. And then we should expect to hear from Judge Boreski. She certainly pumped this out quickly, though, didn't she? I mean, given how lacking I find it, I mean, I suppose she could have probably done it quicker. But anyway, wow, just very par for the course. I mean, I will say, to her credit, it's not handwritten, at least, like some of the other filings. At least it's typed, I guess, right? I guess there's that. I mean, you don't like, the funny thing is, right, is like, she certainly filed this before the deadline, because there's like the clock is ticking, as it were. You have like a certain amount of time to file a motion for new trial, and motions, post-conviction motions, and I don't mean for post-conviction relief, but things like that. I mean, generally, I believe it's either 30 days or 45 days, and I'm sure it varies by the state, but she did this within what, like 2 weeks? She could have taken more time. Anyway, so that was very interesting. So now what we should do, let me just change my time here real quick on my next live stream. For Brian Koberger, so we're going to watch this new video from Law and Crime, and it should redirect you guys. Again, everyone should be able to view it, but it's going to be our members only live chat here to celebrate our members. So, and then tomorrow we will be doing a Karen Reed recap from day 8, I believe. Recap the day. We might do something else as well. I just have to sort of see what else we've got going on. But yeah, there you go, guys. We will be on the lookout, of course, for the responses here to Lori. And there's the email for paralegal. She shouldn't have been. That should be redacted. That should be redacted. Don't email that person, please, people. Oh, God. Yeah. I mean, the juror misconduct is a real thing, right? Like, if the juror was consulting that could be a problem, but she didn't even show that. Like, that was her strongest point. Really, the rest of this is nonsense. This could have had, I don't know. Like, how would anyone know that the juror was consulting other things, or there was anything like that going on, without her laying that out? And she didn't even do that. It's sad, really. Like, she totally missed her chance, because that could have actually gone somewhere. So anyway, I'm going to go ahead and roll the outro, and you guys should be redirected into the next stream. So as always, thanks for being here, and I'll see y'all here in a minute. Squirrel out.